to legal considerations for startups. My name is Rick Martin. I'm an attorney. I practice in the area of intellectual property law in Evansville. Our office is in Innovation Point, downtown Evansville on Main Street. I assume you're here because you either are thinking of starting up a business or have recently started up a business or own your own business and are just kind of looking for ways to improve that process. Before I get too far into it, just want to give you a couple statistics here. About 50% of startup businesses fail within the first 5 years. Furthermore, 77% of startups are formed by entrepreneurs with their personal savings. There's a lot of reasons why these businesses fail in the first 5 years. I'm going to just kind of go over a couple of them, at least as they relate to legal requirements. Oftentimes, people will fail to choose the proper corporate formality, or they'll fail to follow the corporate formality chosen, or they won't choose a corporate form at all. That's one mistake that companies can make. Having weak or non-existent external contracts and agreements, external and internal, with regard to your employees, with regard to your vendors, and with regard to your clients or business associates. Ignoring intellectual property, and that's not only your intellectual property or that you have intellectual property to protect and protecting that, but ignoring the intellectual property of others. And another is failure to get legal advice when it's appropriate and when it's necessary. So those are some of the reasons why businesses fail. There are all sorts of reasons. And I said, you're likely feeling a little bit nervous here. Again, with 50% of the businesses failing, most of the businesses, with 77% of them starting out with the money from their own savings in their own pocket, you're probably concerned about investing your savings and your money in a business where the failure rates are so high. If you want to learn how to protect yourself there and learn how to avoid some of the common mistakes that people make in going into business, then you're in the right place here. We're going to teach you some strategies today that will make it more likely that you're going to be in the 50% that don't fail and the 50% that succeed. And if you happen to be in the 50% that fail, we're going to at least make failure a little easier for you and a little less risky to you personally, and protecting your personal assets so that you can avoid losing anything, your home, your personal assets. So, hang on a second here, I might have the wrong one. Give me 1 second. I got the wrong version up here. That was the Indiana version. I had to come up with the Kentucky version, so give me 1 second. You may have to go with this one on my phone. Give me 1 second. I thought I had a second one up. Bear with me for just a moment. Okay. There we go. Okay, now we're back on track. Sorry about that. Had the wrong one pulled up. So again, I said we're going to teach you some strategies to avoid being in that bottom 50% that will make it more likely you're in the 50% that succeed. And again, if you happen to be in that 50% that fail, at least make it to where it doesn't affect your personal assets and hold you personally liable. Just a little bit of background on me. I'm an entrepreneur like you. At least for me, my journey to entrepreneurship really began several years ago. I graduated from law school in 1994, and went to practice for a large law firm in Texas, where I specialize in intellectual property with that firm. Spent about 4 years at that firm. Got an offer from another firm. Seemed like, you know, the perfect position. It was in Austin, Texas. It was a small firm of about 20 attorneys in that office, and you know, it really looked to me to be the ideal situation for me and where I wanted to be. I spent about a year there, and like I said, the people I was going to work with, you know, I got along with them well. Everything looked like a great opportunity. After spending a year there, that business doubled in size. They brought in, so the group that I got hired to work with brought in 2 new people over me, shifted me over, working for someone else who I didn't quite see eye to eye with on a lot of things. So, you know, after about 6 months there having that situation, you know, I made the decision that not only did I not want to work there anymore, I didn't want to work for somebody else anymore. I didn't spend all of that time going to law school, going to, you know, college, to work for somebody else and to do things their way. I wanted to kind of make my own way. So I moved back here to Indiana in 1999, started up Martin & Martin, which was more of a general practice law firm. My father and I practiced together for a number of years, and then just last year kind of branched off Martin IP Law Group from that, kind of spun it off to kind of start on its own, to focus and specialize on the area of intellectual property law. So I've got some experience. Most of the things that we're going to talk about today are things that I've done myself personally in setting up my business, and it served me well, so I hope it serves you well too. So just getting into the presentation, so there are several things you want to think about as you're starting your business or as you're growing your business. And one, first thing that I think everybody ought to look at or think about is choose a great name for your business. Oh, we'll pause for a second here. Hello.
Hi, I'm sorry I'm late.
Oh, no problem. We're just getting started. So, okay, so like I said, the first thing you want to do is choose a great name for your business. First point I have here, come up with a name for your business. You get bonus points for a name that's arbitrary and fanciful. In trademark terms, there are various designations of names, and the relative strength given to each name depends on what type of name it is. So the strongest marks from a trademark perspective are arbitrary or fanciful names. Some examples of what are arbitrary and fanciful names. Fanciful name is kind of a made-up word. And it might not be a good example, but at one point the word Google was a good example. You know, Google really has no meaning in and of itself, and so they made up basically a made-up name or a made-up word. Now in this day and age, people use that as a verb almost anymore for just doing an internet search, which is another issue, and I won't get down into that too much. Arbitrary names are, here's a good example right here on the back of my laptop, Apple. It's a name that has meaning, but it has absolutely no meaning. It's completely arbitrary as it applies to computers and computer equipment. Beyond that, the next level down, there are descriptive names, suggestive names that suggest to you what the product or service is. Then there are descriptive names that basically describe the product or service. And then finally, generic names, which are not protectable. Again, the strongest marks, the arbitrary and fanciful marks. The descriptive names, sometimes a descriptive name can be beneficial too, but it can't give you trademark protection without developing something called secondary meaning. And what that is that's something that you acquire over time when you use the name. So it wouldn't be registerable absent secondary meaning. I can give you a good example of, I say bonus points for arbitrary and fanciful names. Sometimes a descriptive name may be better depending on what your product or service is rather than an arbitrary or fanciful name. One example, a group that I work with in managing my law practice, the name of the business is How to Manage a Small Law Firm. So you Google, gee, I want to know how to manage a small law firm. You type it in. Guess who comes up first? Exactly what you typed in. So there are a lot of instances where a descriptive name can be beneficial from more of a marketing standpoint. From a trademark standpoint, however, you're going to have to use that name really in commerce until people recognize that name and say, oh yeah, when I Google that, this is who I'm associating it with. And then it would be registerable. Another thing you want to do, I guess so once you've chosen this great name, you want to do a detailed internet search, including variations of that. Also what we call a knockout search, and some of these are elements of a knockout search. You want to make sure the domain name is available, conduct a trademark search at the USPTO database, and also you want to check the Secretary of State website to see if the name's available. So again, just looking at that, so you can go here in Kentucky. I think you can go to the Kentucky Secretary of State's website and conduct just a name availability search, type the name in, and that should give you whether it's available at least for registration in Kentucky. Now, again, I caution you, and I'll tell you an experience that a client of mine has had recently that explains why it's a good idea to do this early on, and why it's a good idea to conduct the internet search, the trademark knockout search, and make sure. I had a client come to me recently who started a business about 2.5 years ago, picked a name, has been actually growing the business, doing phenomenally well with this name, spending a fair amount of time and energy and resources getting to where search engine optimization, where her business is coming up pretty high in searches that are done anywhere. So high that in fact it caught the attention of the person that owns the federal trademark for the same name that she's using, that she didn't discover when she started her business because she didn't do a search. So that's one good reason. Before you spend a year, 2 years, 3 years investing in branding, investing in a name for your business, you really want to make sure that somebody else out there doesn't have it. Just because there's not somebody locally doesn't mean that there's not somebody, in her case, I think the company was in Arizona. They have a federal registration for the trademark, which gives them coverage throughout the 50 states. So if your products or services are similar, they have a good case for infringement, you're going to have to change your name. So best to do the research up front rather than wait 2-3 years down the road when people are starting to recognize your name and then have to change it. You want to form your business. And again, there are several types of business entities that you can choose. A sole proprietorship. I don't recommend you stay as a sole proprietorship primarily because of liability, which is the primary reason to form a separate business entity for your business, is to protect you or to insulate you from personal liability for acts that are done by the business or by the company. So, for example, a product, for example, if you are a sole proprietor and you're selling a product, the product turns out to be defective, somebody gets hurt, dies as a result of the defective product. If you have not incorporated, or if you incorporated but don't observe the proper corporate formalities, which I'll get to in a little while here, you could be personally liable for any damages flowing out of that. Personally liable means, if they sue you, they can take your house, your personal savings, your car, any of your personal assets. So the primary reason to form a corporate entity is to shield your personal assets from liability for acts committed by the company. There's several types: an S Corp, an LLC, a partnership. Probably the two most popular, at least for startups, are the S Corp I think about 42 statistics show about 42% of the businesses that are formed are S corps, about 23% are LLCs. Again, their LLC is easier to create, easier to maintain, less record-keeping formalities. However, if you are looking to have investors potentially or employees, an S corp is oftentimes going to be your best bet there. Again, both of them are going to protect you from liability. What it boils down to a lot of the time is there, which is going to be easier, which is going to be a better fit for what it is that you want to do. That's something you should discuss with an attorney and also your tax advisor or tax planner. And between the two of them, they can generally advise you whether you're best to go with an S corp or an LLC or some other form of business if that would suit your particular situation better. And again, once you determine the type of business entity, you would file the appropriate formation documents with your Kentucky Secretary of State or whatever state you chose to incorporate in. Since we're right here on the river, it could be Indiana, could be Delaware, it could be any state that you choose to incorporate in. I find for most small businesses or startup companies, it makes sense to just incorporate in the state where you're doing business or where you're operating out of. And you also want to register then with the Kentucky Department of Registration or Department of Revenue and the Department of Workforce Development if you're going to have employees. You would need to apply for an EIN, an Employment Identification Number, through the Internal Revenue Service. Again, primarily if you have employees, but there are also several other things in dealing with vendors. People are going to want to do W-9s. Everybody's going to want to know. It's basically the Social Security number for your business. So it's a federal ID number that you need to, again, establish that separate legal entity and a way for the federal government to follow and track the goings-on of that entity. If you choose the S corp, so you file your incorporation documents with your Secretary of State. If you go with the S corp option, there's a separate filing that has to be done with the federal government. It's called the Form 255030, and that has to be done within 75 days of you filing your corporation documents with the Secretary of State in order for it to apply for that particular year. Essentially, what an S corp does, or the benefit of an S corp as opposed to a C corp. So when you form, you would be a C corp. You would designate the sub S designation, which gives you pass-through taxation. So from a taxability standpoint, the corporation is not going to be taxed first, and then you're not going to be taxed on the earnings. All of the earnings, all of the profits would pass through directly to the owners of the business, and then they would be taxed on their personal returns for the income. You wouldn't have, so with a C corp, the corporation is going to file a tax return. The corporation is going to pay taxes on the income of the corporation. Then they make distributions to the shareholders, and the shareholders then pay taxes on that as income. With the S corp, you don't pay taxes twice. You just pay taxes for one time. The corporation doesn't pay it. You just pay it on the personal earnings. Then just quickly, so you want to open up your bank accounts to maintain your business funds. I recommend opening a business PayPal account. Makes, in the online world that we're in now, it makes transacting business not only for paying, but for receiving funds much easier and much more efficient. You want to prepare your internal documents. And again, these are your operating agreements or your bylaws, particularly if you're if this is a situation where there are more than one person that have an interest in the company. You want to know, you basically expect the best, prepare for the worst. You want to know if this thing goes south, if this doesn't work out, or if we come across this situation, what are we going to do? What governs, what controls, and the bylaws or the operating agreement essentially are the Bible, if you will, for the business as to here's how the company is going to be run, here's who owns the shares, here's the way the company's gonna run. And if there's disputes, here's how we resolve those. And again, you wanna make a corporate file to keep all of these papers in, keep them in the same place, keep them together. You wanna set up monthly payments for your taxes, to optimize your company's tax treatment. You wanna document all of your major business activities. Purchasing equipment, hiring employees, contractors, things of that sort. And again, I think it's also very important to purchase business insurance for your company. And it may be, as a startup, it may be something that's a fairly low cost, but I think it's well worth the money spent. I suggest that you find your local insurance agent here, or someone that deals with businesses or startups particularly, that would know what type of coverage to get. If you've got employees, obviously you're going to need maybe workers' comp and some additional coverages. But most insurance professionals that are familiar with selling insurance to businesses will be able to help you with what you need to get running. And again, as a startup, it's probably not going to be too terribly expensive. You'll want to get a DBA, a doing business as, if you're doing business under another name other than the name you incorporated under. Again, if you're doing the DBA, we'll circle back to the last slide, you want to run a check on those names too, because you don't want to be in a situation where you're using this name, you're building this goodwill with your customers, and only to find out a couple years down the road that you can't use that name anymore because somebody else is and has trademarked it.
A question on that?
Yeah.
Is there, say you got an LLC, is there a limit on how many DBAs you can run under a?
No, not really. I mean, as many as you can add. There's no legal limit on that. From a logistical standpoint and a practical standpoint, there may be some issues with that. You may want to, for various reasons, you may want to form separate related companies if the businesses are not if the businesses are distinct enough, and if there's some liability issues here that aren't here necessarily, it may make sense to set up separate businesses to shield this business from the liability of this business. But as far as DBAs or names, no, you can have as many as you want. As a practical matter, it's going to get confusing if you're calling the business multiple things. So I guess my question is, are you talking about multiple businesses operating under the same umbrella?
Yes.
Okay. Yeah, so I guess that question would be, the answer would be yes. You can have as many as you want, but it might make sense to separate them for liability's sake. Okay, so license your business. And this may or may not apply, but certain types of businesses, the state and or federal government may require you, and or locals at times too. You may have to purchase or to acquire a license. Some common things: alcohol and beverage sales, retail food sales, daycare centers, financial services. Those are all businesses that typically require a license from at least the state, if not from local as well. So you want to, if you operate a business, I mean, that may be subject to those, and actually you can go to, again, I'll click on this, the state of Kentucky, the Secretary of State's website here has a place where you can go, and they've got it. It's this portal, the one-stop business portal. There are a lot of useful information on here. This is, I think, this is the second or third time we've gone to this website in various places. So searching permits and licenses here. And if you have any doubt as to whether or not you need a permit or a license for your particular type of business, you can go to this page, type in the type of business, hit go, and it'll at least point you in the right direction as to whether or not that's something that you might need to get a license for. Okay, next, the highlight of the presentation, at least for me. So, protect your intellectual property. And a lot of those of you who are here, how many of you have intellectual property? 2 of you? I'll business, you probably have intellectual property of some sort, whether you realize it or not. Intellectual property generally covers four main areas of intellectual property. You have patents, which cover inventions and things of that nature, and that's what most people think of when they think of intellectual property. They think of patents. However, that's not where intellectual property ends. Trademarks, trade names, trade dress, those are all intellectual property. So if your business has a name, your business has a logo, anything of that sort that you want to distinguish yourself from everyone else by, that's intellectual property. Copyrights, if you have software, if you have artwork, designs, things, again, logos that go with your business, those are all protectable by copyright law. So you've got intellectual property there. Trade secrets, again, if you've got customer lists, I mean, that's a common thing that most businesses don't want their competitors to have. So they hold that closely. They limit who has access to their customer lists. That's a trade secret. That's intellectual property. So there's all kinds of intellectual property. Just because you don't have a tech-based business or something where you're going to have patents or something that's patentable, almost every business out there is going to have intellectual property at some time or another. At least if that business has significant value to it. And in this day and age, there are many companies, the bulk of their value is in intellectual property. I mean, companies like Apple, like Google, that have patents, trademarks. I mean, the trademark on Apple, what's that worth? It's worth a lot of money. So, yeah, I think I've read some statistics here somewhere where companies like Apple and Google, about 75% of their value is in their intellectual property. So it's certainly not something to overlook. It's certainly something that I think all business owners ought to look at and see, do I have it? And if so, how do I protect it best? Yes?
Well, I had a question about protecting it best. I have a startup in Evansville, and it's a tech startup. It's an app and a software service, basically. And we're getting to the point where, we're doing a lot of presentations, we're in business competitions, and now we're to a point where we are presenting to investors. Is like a non-disclosure form best? Or how do you, because for us personally, we're on this line of wanting to shout to the rooftops what we're doing because we're excited about it, but at the same time, we're also in a position where someone with more money, if they got a hold of some of our core ideas, could take it and get there before us.
Well,
so we're in a weird spot.
And I'll go ahead and answer that question here. So it depends. A non-disclosure agreement, let me back up. So with regard to patents and acquiring rights for a patent, up until about 2012, the United States was on what was called the first to invent system. And what that meant was if there's ever a dispute at the patent office, you have two people file for the same thing to try and patent the same thing. They would institute a proceeding within the patent office to decide, okay, whose application gets to go forward. And what they would determine at that point would be, okay, you would bring in all of your documents and all your records that would show when you invented this, when you came up with this idea, and then when you reduced that idea to practice. And you probably, anybody that's ever been in the tech business has probably heard what they commonly used to refer to as a poor man's patent. You write it on something, you put it in an envelope, and you mail it to yourself.
Yeah.
And that's exactly what that did. A lot of businesses and a lot of businesses I work with, and there's still reasons to do this, but I would have their engineers keep a notebook and date it, have it witnessed. Probably not as much reason to have it witnessed anymore. But the whole idea of that was you have a document that's stamped, dated, that says, okay, as of at least this date, you know, I've invented this. And so if you ever got into one of those disputes in front of the patent office, that would be your evidence to show, hey, this is when I invented it. So that's kind of an academic discussion here, because in 2012, we went to a first to file system. All that's out the window. All that's completely useless anymore. If two people come up with the same thing and file for it, whoever gets the patent office first wins. So one of the risks you run, a big risk you run in telling people your idea or talking about your idea, is that somebody else is going to take that, tweak it a little bit, and go file a patent application.
Yeah, because we're getting ready to, we're working with USI through like the incubator program, and we're getting ready to like do like really intense patent search to make sure that we aren't stepping on the toes of
Right.
any patents before we go, you know, to potentially patent our own technology. But then, you know, we start looking into all of this, and then you start hearing about patent trolls and all of this other crazy stuff within like the tech world, and it's just intimidating.
It can be, and I understand where you're coming from on that. I tell you, I'll loop back to that. I'm going to go ahead and kind of work through the presentation. We'll have a period for questions and answers, but I'll follow up with you on that here afterwards. But yeah, that's the other thing too, is, I mean, you want two sides to that equation. One, you need to, and I think that brings up a good point, not only do you, well, one, want to try and acquire and protect your intellectual property. Once you have it, you need to monitor it for infringement and make sure that you're policing it appropriately, and then if other people are infringing it, that you take appropriate action. At the same time, you also need to be taking at least some steps to make sure that you're not stepping on other people's toes by infringing their patents as well. So, conducting an intellectual property audit, again, it's something I recommend most people do, or most businesses do annually. As a startup business, it probably isn't going to take very long to do one. As your business grows each and every year, as you acquire more intellectual property, as you acquire employees, as your business grows, the need to do this grows, the complexity of it grows. You're acquiring new trademark rights, you're having software developed, you have copyrights, you have patents, and all that kind of comes in here. The purpose of the audit is, there can be many purposes of an IP audit, but I recommend it at least annually to most businesses, just to take stock of what we have and how do we best protect it. And again, if it's done periodically, it's kind of more of an update thing than it is anything else, and it's just a good idea, I think, to stay on top of your intellectual property and how to best protect that. All right, move to the next one. So, legalize your website. I guess first of all, do you all have websites for your businesses? I would almost think I wouldn't have to ask that anymore, but I mean, I think every business should have a website. With as much commerce as transacted online anymore, I think it's almost critical. Again, and I had the statistic earlier, so I may be a little off on this, but read a statistic where the average, and I don't know what exactly they're defining as small businesses, but the average small business in the United States makes about $3.6 million in revenue a year. If they have a website, that's 5.3 million. So just the law of averages there. You know, having a website is going to increase your chances of business. It's going to increase your exposure. It's going to increase, should increase, if it's a well-done website, it will increase the traffic to your business and should be helpful. But as part of that, again, you want to draft and post on there privacy policy and terms and conditions. And again, just to protect yourself with regard to your products or services, you always want a disclaimer on there as to what you'll see an example one here at the end of the presentation as well. But as to what your products are and are not, what they should be used for and what they should not be used for. You should probably check with the FTC advertising regulations, or if your particular field is regulated, like I am as an attorney, you'll want to check with any advertising regulations that the FTC may have or that may be particularly attributable to your profession, to make sure that you're in compliance with those. Review and comply with any anti-spam laws. And again, you want to make sure that you have the rights and permissions to use any intellectual property that you use on your website that you don't personally create. So if you're using photographs, these stock images, don't just pull images off the website and assume that it's okay to use those. I would err on the side of buying every single image that I'm going to use on my website. That's what I've done. If I have stock images, I've paid for them so that I know that I have the rights to use them. There's some places out there where you can get stock images for free, but just make sure you go to a reputable site to get those, and make sure that you do have the permissions and the rights to use those with regard to your site. And again, you want to safeguard the information you collect from visitors, particularly financial information. So people are paying you over the internet. You need to make sure that's secure, and just be relevant and know the laws with regard to minors and usage of your website there too. Again, it's also a good idea just from a practical standpoint, not from a legal standpoint. Social media, Twitter, Facebook, just all of the other avenues that are out there to help kind of promote your business and kind of cross-link everything. I think that's very helpful from a marketing standpoint. Legalize your relationships. And again, this refers to what I'll call your internal relationships and your external relationships. So from an external relationship standpoint, your agreements with your clients, your agreements with your vendors, all of those things should be done in writing. Handshake agreements, while that is all good and fine. When things go south, which if you're in business long enough, they will. It's always good to have a written agreement to fall back on, and I think it's good just to have that so that there's no misunderstandings as to what the agreement is and what the arrangement is. And the agreement, all of it can be spelled out in a written document, and that's what you have to fall back on if and when things go south, because eventually they will. And if you have it down in writing, it's a lot easier to get the situation resolved in your favor. You want to make sure you draft the agreements, and again, we talked about the bylaws or the operating agreements that govern the ownership of your company. Who are the owners? What shares do they own? What happens if somebody passes away? What happens if there's a disagreement or a dispute? Who has controlling interest? Who has right to vote? All of those things need to be addressed in the operating agreement so that if there's ever a dispute between the owners, it can be resolved. Now, if there's a single owner business, less likely that you're going to need that, but certainly anytime you have multiple people owning a business, it's good to get it down in writing as to who owns what and what happens if things don't go as planned. And again, if you need an office, retail space, warehouse space, you're going to want to have an attorney review the commercial lease agreement before you sign that and move in. From an internal perspective, your employees, you're going to want to have agreements, documents with your employees. This is very important, particularly in the intellectual property area. If you have employees that work for you and potentially develop intellectual property as part of their job duties in working for you, you want to make sure that it's spelled out in their employment agreement that you own the intellectual property, not them. Otherwise, there can be disputes down the road as to who owns it. They may claim ownership in it. If you don't have a written document that says they have an obligation to assign that to you, it's entirely possible that your employees could claim ownership or rights to the intellectual property that you paid them to create. So it's a good idea to always have that down in writing with your employees, establishing what their duties are with regard to intellectual property that's created as part of their employment. or otherwise. And I've seen that all over the place. There are some companies, some larger companies, will draft agreements that go so far as to say, yeah, I don't care if you created this on your day off in your garage at home, we own it, if it's patented. To where, to the other, the more reasonable end of the spectrum is if you created it on our time, or if it relates to our business and our industry, we own it. And there are various things that can be done to compensate them, or maybe their salaries compensation. But all of that needs to be spelled out in some kind of written agreement so that everybody knows who owns what. And lastly there, and again, this gets to, in all of these agreements, I strongly encourage you to put an alternative dispute resolution clause in the agreements, both in your internal and in your external. And particularly as it relates to intellectual property, litigation is, and I've had a couple clients refer to it as the sport of kings. It's a very expensive proposition to litigate patent infringement, validity of a patent, things of that nature. Trademark, not so much, but it's a significant expense to get involved in litigation of any sort, particularly intellectual property litigation. So if you can, one, follow a lot of the things that we've talked about here today, that will help you avoid disputes. But disputes are probably inevitably going to arise. If your contracts have alternative dispute resolution clauses, which would go arbitration or mediation or some other, I guess, threshold or some other step that you have to go through before somebody can file a suit and before it can go to court, oftentimes that will resolve a case or resolve a dispute at a significantly less expense than if you were to litigate it in court. So I would encourage you in all of your agreements to make sure to have those alternative dispute resolution clauses in there. I think this may be the last slide, or it's getting very close to it. So if you have employees, be a good boss. You want to make sure your workers are properly classified. Some of your workers may be independent contractors. Some of them may be actual W-2 employees. So make sure you know what their classification is, and make sure they know what their classification is. Draft and sign agreements for all workers. And again, I think we covered a little while ago why you want to do that and why it's important to do that, particularly in the area of intellectual property. And again, depending on what your situation is with the employee, you've got to be careful to some extent not to draft it to where they're not what's considered an at-will employee. And an at-will employee is somebody that essentially you can be terminated at any time for any reason other than discriminatory reasons. You want to be careful in drafting your contracts, generally not to put somebody, or not to take somebody out of that category, because then it makes it much more difficult to get rid of problem employees if and when that happens. Make them fill out the Form I-9 for immigration purposes, the W-4. Familiarize yourself with the Department of Labor laws and regulations regarding employment. Make sure you post all the labor law posters, and there are places to go to get those. And again, this is all if you have employees. If you don't have employees, or until you have employees, you don't necessarily need to worry about these steps. But once you have employees, it's certainly something you need to do. Again, familiarize yourself with federal discrimination laws and abide by them. And again, that gets back to what I talked about before. You can generally, if you have an at-will employee, you can terminate them for any reason other than, it's not an exhaustive list, but race, sex, age are some of the big ones there that you cannot terminate somebody for those reasons or discriminate against them because of those. Obviously set up your payroll and register as an employer with your state. We covered that a couple slides back. Obtain insurances for your employees. I think we talked about that too. Workers' comp is certainly a big one to have. Disability Health insurance, again, I don't think that's required in most places. Certainly something that's optional, that if you want to provide that for your employees, you can. Up until you get to be a rather large business, you don't have to do that in most places. Again, generally establish some policies and procedures for your employees, an employee handbook that should cover things like social media policy, and any number of other things. And again, make sure you keep your records up to date with regard to your employees, vacation time, things of that nature. So, again, here's the disclaimer I told you would see at the end, so not too different from a disclaimer that you would have on a website. I think that pretty well concludes the main part of my presentation here. We'll get to a Q&A here. We'll start that up in just a moment. And let's see, we probably got about 15 or 20 minutes for Q&A here. If we want to do that, I guess before I go into Q&A, I want to thank you all for coming today. And as a thank you for coming here, we would like to offer you what we call our startup checkup. And what this is a chance for you to come and sit down with me one-on-one, tell me about your business situation, your business scenario, what you've got going on, and we'll kind of look at your individual situation and give you recommendations on what we think you need to do to make sure that you're covering yourself from a liability standpoint, and that you're also protecting your assets, protecting your intellectual property. By coming here today, we're going to offer that as a free service to you. If you want to check with Caitlin here at the end of the presentation or at the end of Q&A, she can set you up an appointment, or if you're not able, if you don't have your calendar here today and you're not sure what works, she'll give you a card, and as long as you call us by Friday to set an appointment, we'll set that up for you free of charge.
I have an evaluation when you're done with your question and answer.
Okay, great, thank you. So anybody have any questions? So.
If when consultants go out, like when a consultant does certain things, say they're doing whatever, team building or organizational development or whatever, professional development. So they're out there using their intellectual property that they've come up with to do this. How do they keep somebody else in that room from stealing that and going out and doing it themselves?
Well, and I guess maybe I'm a little confused. What is it that they're, and I don't want a specific example, but what intellectual property would they be sharing?
Well, let's say there's a management idea, just use that as an example.
Okay.
That doesn't exist today out there. This person's come up with it and goes out and starts teaching it.
Okay.
For you to use, but not for you to go out and start selling it yourself.
I mean, so are they teaching it for free, or are they getting paid to teach it?
Mm-hmm.
I mean, I would think that the way you would handle a situation like that would be with your contract, your agreement. So you're going to enter into a written agreement with whoever it is you're teaching this to, that what this information we consider to be proprietary. This information is our trade secrets. As a client or as a customer of ours, we're sharing that with you. That is solely for your use, not for distribution otherwise, not for use outside of here. So you have a written agreement that governs the parameters of what they can use, how they can use it, where they can use it, and when they can use it. And if they stray outside of there, then you would have an action against them for trade secret misappropriation. That answer the question? I think that seems. I think I got the. If I got the question right, I think that answers it. So. Anyone else?
So, another thing that we're deciding right now is between an LLC and an S Corp.
Mm-hmm.
And we're having another meeting on Sunday about this. We had, 2 out of the 3 of us had a meeting with our advisor on Saturday, and they were like, oh, well, let's just do an LLC, basically, essentially, because it's easier, and our third partner wasn't there, so I didn't really, dive into it. Well, I'm kind of gonna dive into it more, on Sunday. Where does the line, where do you draw the line? What, do you have rule of thumb or something? If you're a tech company, you need to be, how do you know?
I said there are no bright lines. Like I said, an LLC is easier. Again, it's harder to convert than once. I mean, if you're an LLC, then it's hard to switch over to a corporation.
Because you mentioned that, if you were gonna have investors and partners and things like that, it's smarter to have an S corp. So
I think typically most investors want want to
because
see
we've
that.
got, right now, we have our 3 co-founders,
Mhm.
and we have the start of a technical advisory board, but that advisory board has no idea what they're getting out of this yet. We're settling all of this, right now. So because we're going to have, an advisory board that's essentially going to get a small percentage of the company once we start making profits, do you think it would be safer for us from a legal standpoint to go with the S corp, even though it's not as easy as the LLC?
I would say, given that general scenario, I think that's probably the best bet. So, follow up with her and say, that's probably better a one-on-one. Get your whole scenario,
yeah.
and so come in for a startup checkup. We'll sit down and look at all the angles, and at that point, I can probably tell you a little better than I can off the cuff up here. But
Okay, we'll do that.
from what you're saying, yeah, it sounds like that's probably that may be a better fit for you down the road, and it doesn't make sense to start down this road when you're really gonna be over here later on, so it's harder, it's difficult to switch, so.
Have you thought about doing something like this in Evansville too?
Yeah, and I appreciate you coming all the way over
You
here. I'm
should
probably
do
gonna
it.
do
You
it,
should
I'm
do it.
probably
There's-
going to do it in Evansville next month,
We have a
so.
strong startup community over
I know.
there, so.
Well,
I'll probably be at that one too.
Yeah, it'll be at Innovation Point, so we'll have it there
Yeah,
somewhere.
that's my
so.
second house.
Yeah, okay.
It's a cool place.
Well, you won't have too far to come and visit us for the startup check.
I was gonna say, we'll just schedule it the same day.
Yeah. All right, good. Any other questions? All right, well, again, thank you all for coming. Check with Caitlin there for your startup checkup. Like I said, either schedule an appointment with her. She's got the calendar there today, so if you want to schedule something today, you can do that. Or if you don't have your calendar and you want to schedule something, she'll give you a card, and then just, again, call us by Friday and schedule your appointment. We'll be glad to help you out with whatever you need. Okay, and thank you all for coming.